Hi, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to present you to the Elite 8 of the Harlan Institute ConSource Virtual Supreme Court Competition 2019. This year, our tournament focuses on the case of Espinoza versus Montana Department of Revenue. We are honored to have teams from across the country participate. Representing petitioners from Creekview High School in Texas, we have Elizabeth Adeoye and Yashica Nabar. And representing the respondents from Lake Oswego in Oregon, we have Elliott, Lloyd, and Lance Pancoast. And petitioners, you can begin whenever you're ready. You have 15 minutes. Okay? Whenever you're ready.
And my name is Yashica.
And we represent the petitioners in today's case, Kendra Espinoza, Jerry Anderson, and Jamie Shaker. Today's case is about whether or not Montana's Constitution can supersede protections made by the U.S. Constitution. And, Your Honor, the fact of the matter is that it cannot. We will address 2 points. The first being that absent Rule 1, the tax credit program is constitutional. Using precedent set by Trinity Lutheran, Comra, and Vilna v. Sibley Terrace, we will argue that absent Rule 1, the tax credit program does what it intended to do, help students and taxpayers and it protects the Constitution. The second point we will address is how Montana's No Aid Clause, as applied, was unconstitutional, not only because of its discriminatory background, but because of its precedent shown by Rosenberger director.
In 2015, the Montana State Legislature created a tax credit program for taxpayers that donated to scholarship organizations. The Montana Department of Revenue found that the program was not in compliance with the Montana State Constitution and issued Rule 1, which nullified the tax credit program. Mothers of students affected by this rule contended that this issue was unconstitutional, and this action violated the Free Exercise Clause. Initially, in the Montana Judicial District Court, the court ruled in favor of the petitioners, ruling that it is in violation of the Free Exercise Clause to invalidate a generally neutral tax credit program on the basis of religion. However, the Montana Supreme Court reversed the lower court's judgment. Through this decision, the group of parents and their children were stripped of the choice in wanting to attend schools they desired. Then they appealed to the U.S. Supreme Court to get justice for their children. The tax program
Counselor, if I could,
was constitutional.
Counselor, if I could ask a question. So let me ask a question at the outset. What is the basis for Article 3 standing in this case? What is the basis for Article 3 standing?
Article 3, Your Honor, or Article 10?
Well, no, I'm talking about what is the injury that Espinoza suffered here? What exactly is the injury?
Well, in this case, not only Espinoza, but the 3 mothers and their children were not allowed or were not able to attend the school that they wanted to, in this case, Stillwater Christian.
Well, now, Counselor, if I could interrupt, they could attend, they just wouldn't get these scholarships.
Well, Your Honor, not everybody is in the same situation, and they were dependent on this tax credit scholarship in order to attend the school of their choice.
All right, well, Counselor, explain to me, how exactly does this tax credit system work? Walk me through the process.
Well, Your Honor, a private citizen can donate to a SSO or a student scholarship organization and will be granted up to $150 tax credit for their tax for that year.
Okay, so is Ms. Espinoza a taxpayer? Was she one of the people who gave the money to this program?
No, Your Honor, she was one of the people that would be able to get the scholarship.
But let's be precise. Will the tax credit go to Espinoza, or is it going to the school?
Well, in this case, it would go to Espinoza because they do allow scholarships for specific schools, but it is going to...
No, but why isn't the school the one challenging this program? It seems it would be the school and not a parent who should be upset at this.
Well, because the school will still operate with or without the tax credit program. It's the parents that want to go to the school and be a part of the scholarship that won't be able to benefit from it because of the leveling down.
Okay, you may proceed.
The tax credit program was constitutional at the support of Rule its facilities, it gave a neutral policy that any student groups would be allowed to use it. They argued about a neutral policy towards religion would achieve an obligation that complied with its constitutional objectives. In today's case, the Department of Revenue will argue that the issuing of Rule 1 was to fix the unconstitutionality of the original document, when the ideas of this case would show that this was unnecessary, as before Rule 1, religious and non-religious students benefited equally.
Counselor, let me ask you a question. Guys, let me ask you a question if I can. Do you think that the Montana Constitution, Article 10, Section 6, is it unconstitutional as applied or unconstitutional on its face?
I'm sorry, Your Honor, can you please restate the question?
Do you think that the no aid provision in the Montana Constitution is unconstitutional as applied or unconstitutional on its face?
If I may answer this one, Your Honor, I believe that this is unconstitutional as applied. It would be argued that facially the wording of this document only means that there will not be any direct intertangling with religion and government, but as applied, there is discrimination between religiously affiliated students and non-religiously affiliated.
But when would the Montana Constitution be valid, the Article 10, Section 6, right? Under what circumstance would it be valid? Under your theory, it's always unconstitutional, I think.
Well, yes, Your Honor, the direct wording of it would be always unconstitutional. However, through the wording, when it was originally instated, there were different beliefs. So, facially, it was okay at the time, but it was just used as a pretense for discrimination.
All right, well, let me ask a follow-up then. What's the strongest case in your mind for why the no aid provision is unconstitutional? What's your strongest case?
Well, I believe that all my cases in my argument are strong, but I also
Pick one.
believe that Trinity Lutheran v. Comer would be one of the stronger ones, and also Zelman v. Harris. I understand that it might be argued why Trinity Lutheran would not be strong, but I will continue to argue that.
Well, but let's talk about Trinity Lutheran for a bit, right? In Trinity Lutheran, we're dealing with tire scraps, right? And tire scraps are not something you use in a religious service, right? Isn't that case different from yours?
Yes, while it is different, I'm not looking at the direct holding or the facts in this case. I'm looking at the principles that are set in this case, like the fact that the church said that the exclusion of churches from an otherwise neutral and secular aid program violates the First Amendment guarantee of free exercise. Is there anything in Trinity
Lutheran that limits the holding? Is there anything that tells us how you might limit that case?
Well, footnote 3 might limit that case, Your Honor. But
okay, yeah, good. That's what I was getting at, what you anticipated. Let's talk about footnote 3 for a minute.
Yes, sure.
What does footnote 3 say?
Well, I don't have the direct wording of footnote 3, but it says that it is only pertinent to the facts of that case, being that there was a tire surfacing for the playground. However, I'm not using the holding of that case. I'm using the principles that were applied in that case.
Okay, you can proceed, Counselor. Or Yashica, whoever you can proceed with the argument.
James Madison's memorial and remonstrance against religious assessments argued for religious freedom. Madison thus led the government to not only further expand the list of multiple religions being exercised within a majority, but also allowing Americans the right to complete religious liberty. Similar to this, Thomas Jefferson wrote a series of letters to Danbury Baptists addressing how the act of the whole American people, which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof. By saying this, he created a basis of how officials should create laws that do not endanger religiously affiliated citizens of the United States.
But Yashica wasn't.
Argument, as Thomas Jefferson, who is not only a framer.
Hold on. Did you just say Jefferson was a framer? I'm sorry. Jefferson was not a framer. He wasn't. He was not at the convention. He was in France. But let me ask the question that I was going to ask. Wasn't Madison's concern in the memorial was about state funding of religion, right? The state was giving money to churches. They were taking taxpayer money, giving it to churches. Isn't that exactly what's going on in Montana? They're worried about taxpayer money going to religious houses of worship. Doesn't Madison hurt you in that regard?
Well, Your Honor, in fact, I personally believe that it doesn't, because by not allowing state funds to go to places where people should be freely exercising their beliefs, it's holding them back and penalizing them for doing so. So it kind of connects to this case, because by not allowing state funds to go to religiously affiliated schools, it's kind of holding them back from being able to achieve their religious aspirations, as you may.
Okay, you can pursue with your argument.
By saying this, let me go ahead and go to... It only makes sense to use this liberty by allowing everyone to follow whichever beliefs that they may.
Oh, I think you're on mute. Go ahead.
Of the First Amendment states that Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. The Supreme Court goes into violation of that. And then Harris, the court set up a 5-pronged test to test whether or not a voucher program is constitutional. Even though the matter in today's case is not a voucher program, but about a tax credit program, this just goes to show the basis of constitutionality of government aid and programs. The test is 1, the program has a valid secular purpose, which in this case is the education. 2, aid must go to parents, not schools, which in this case it would be. 3, beneficiaries must have, and any religious or non-religious school can benefit. And 4, the program must be neutral in respect to religion. There is no favoring between religious and non-religious students. There must be adequate non-religious options, which is in this case the many secular private schools in Montana. Using the standards and rationale set in Trinity Lutheran v. Commer, the tax credit program in this case is constitutional. It was deemed that as long as religious and non-religious entities were given the same opportunities or the lack thereof, then the program in consideration is constitutional.
Well, Counselor, why can't Montana go above and beyond? We agree that there would not be an Establishment Clause violation. Why can't Montana take extra efforts to ensure the separation of church and state? Why can't Montana do that?
Well, Your Honor, it is within Montana's power to create a constitution for their own constituents, but the supreme law of the land is the U.S. Constitution. So anything that the Montana Constitution says that is trying to supersede anything that's protected by the U.S. Constitution is not unconstitutional.
Okay, you can proceed, Counsel, and you have about 3 minutes left.
The next point the petitioner will address is how Montana's no-aid clause is as applied by the Constitution. The Montana Department of Revenue's rationale behind issuing Rule 1 of the tax credit program was unconstitutional under the Montana's no-aid clause. States with no-aid clauses argue that the reason are enslaved state, but after a look at the background of these amendments, it has a history of prejudice against religion. From its inception, these
I think you froze, Counselor. Oh, I'm sorry. Yashica, do you want to...
I'll just clear, yeah.
Yeah.
It has a history of prejudice against religion from its inception. These amendments were put into place to discriminate against Catholics, as Catholicism was not the majority practiced religion. The senator that wrote the original Blaine Amendment was not only racist, but anti-Catholic, and the purpose of these laws were to be discriminatory. The discriminatory
Well,
background...
let me ask you a question. Let's just agree for the moment that James Blaine was a racist, and I'll agree with you there. What year was the current Montana Constitution provision ratified?
I'm not sure, Your Honor.
All right. Well, the answer is 1972, right? So just we'll accept that. How should we consider racism from the 1800s for a provision that was enacted in 1972?
Your Honor, well, as it was somewhat normalized at the time, I feel that it was still in the wrong. So I think we should still take into account how it had a negative impact on our society.
Okay. You have about a minute left, Counselor?
Okay. All right.
I'm sorry.
Your Honor, the dangers
and if you can just maybe call during the break your partner to bring her back in. But yeah, you may go ahead.
In our favor today heavily outweigh any arguments the respondents may make by not reversing the decision of the Montana Supreme Court, a dangerous precedent that allows states to not only disregard the U.S. Constitution, but also giving them a clear path to legalize unconstitutional discrimination. If there was a pool and the owner didn't want any minorities in it, so instead of allowing equal access to the swimming pool, he just closed the facility. Would that not be constitutional? No, it wouldn't. So why should it be on the matter of religion? It is for these reasons previously stated that we pray this court reverses the decision of the Montana Supreme Court and takes note of the unconstitutionality in the issuing of Rule 1 and rules in favor of petition.
Okay. And Elizabeth, your partner just finished her final minute and you're out of time, so I'm glad you're back. We will now move on to the respondents, and you have 15 minutes. Elliott and Lance, you can begin whenever you're ready.
Thank you, Your Honor. May it please the court that I, Elliott Lloyd, and my partner Lance Pancoast represent the respondent, Montana Department of Revenue, in the case Espinoza versus the Montana Department of Revenue. The question presented before the court today: does it violate the Free Exercise Clause to invalidate a generally available and religiously neutral student aid scholarship simply because the program affords students the choice of attending religious schools?
Your Honor, here are the facts of the case. The 1972 renewal.
Well, Counselor, I think we're familiar with the facts of the case, so you can move on to your argument.
Yes, Your Honor. Elliott, would you like to start?
I will. Today we will argue two main points. First, that Locke v. Davies shows that there is room for play within the joints between what is permitted under the Establishment Clause, what is in protecting the rights under the Free Exercise Clause. Second, we will look at the original intent of no-aid amendments to show that no-aid amendments are constitutional. First, I'd like to discuss Locke v. Davies. Like Montana, Washington had a no-aid clause that prohibits states from funding religious instruction. And Locke v. Davies shows us that states are not required to fund religious instruction under the Free Exercise Clause. Yes, if they're interested, they may offer scholarships under the Establishment Clause, but they are not required to do so. Like Washington, that is exactly what Montana is doing here. They're excluding a certain category of instruction from state funding, and that is acceptable under Locke v. Davies and does not invalidate the rights of the petitioners under the Free Exercise Clause. Locke v. Davies shows that states can act differently towards religious education and that they have a vested state interest in ensuring the wall of separation. As referred to earlier by our opponents, Thomas Jefferson's letter to the Danbury Baptist shows that since the founding of our Constitution, there's been a vested government interest in separating this church and the state, and that there is a valid religiously neutral reason for yes, Your Honor.
Your Honor. Counselor, can I ask you a question, please? Let's start with Trinity Lutheran. It seems that that's not a good case for you, that Trinity Lutheran, and your friends made this point well, that Trinity Lutheran says you can't discriminate on the basis of religious status. How do you get away from Trinity Lutheran? How do you distinguish your case?
Lance.
Your Honor, in Trinity Lutheran v. Church, the Trinity Lutheran was incorrectly denied the rubber on its status as a religious institution. However, the grant itself was not religious in any form. Nobody is going to say that playground rubber surfacing is going to further the religion, especially since the grant is generally available for all schools. So even if a religious school were to benefit from it, it would equally benefit from it the same as all other.
Now, Counselor, let's talk for a bit about footnote 3 from Trinity Lutheran. How do you square the position with footnote 3?
Your Honor, I'm not completely familiar with footnote 3.
All right, are you familiar with Justice Gorsuch's concurring opinion? Or Elliott, do you know footnote 3?
Yeah, I can discuss footnote 3 a little bit.
Yeah, let's talk about footnote 3.
Footnote 3, says that Trinity. This case is specific about the playground tires, right? And that this holding might not necessarily apply to other cases such of this nature. And I think that if we look at Trinity Lutheran and how it regards to this case, we can also see that in Espinoza versus Montana, we're not arguing about whether or not Rule 1 or the program with Rule 1 was inconstitutional. What we're arguing is the invalidation of the program is inconstitutional. And I think here we see that in Espinoza v. Montana, the solution to this problem, even if we conceded that Rule 1 was unconstitutional, the solution is completely appropriate because it invalidates the entire program for secular
let's go back to Trinity Lutheran for a bit. I think you got footnote 3 correctly. Justice Gorsuch wrote a concurrence. Are you familiar with the Gorsuch concurrence?
I'm not, Your Honor.
Okay, well, Justice Gorsuch made this argument. He said there's a difference. He says there's not much of a difference between religious status and religious use, right? Any religious organization will advance religion what it does, right? Trinity Lutheran has a playground there as a means to advance its religious mission, outreach. When will you ever have religious status that's not also a religious use, right? How can you disentangle those two? Every religious school advances religion. That's why they're religious schools.
Your Honor, if I may.
Please.
So I think we can both agree that there is an extremely distinct difference between rubber tire scraps, which will just reinforce a playground that is affecting everybody, versus a scholarship, which directly affects the followers of a religion. I think to not make the distinguishment between generally available playground versus versus non-secular education, to make the comparison between the two would be overlooking the incredible impact that religious education has on the religion.
I think.
Yes, Elliott.
Well, go ahead.
I think even there we could go back to Lemon a little bit, because in Lemon we see the opinion that they say that the reason the Lemon test was created is because that primary school students are particularly impressionable minds. And I think there's a big difference, like Lance was saying, between the benefits of a playground that anyone in the area could use, not just the school, and actual religious education to these impressionable minds of primary school students. And so I think that just really clarifies the distinction between why tire scraps versus religious education. Even though tire scraps are obviously associated with this religious school, there is that really a distinguishable difference.
Okay, you can pursue with your argument. Go ahead.
Would you like me to argue Nyquist?
Whatever you want to argue.
So to bring up another case, in Committee for Public Education, Religious Liberty versus Nyquist, there was a tax program put in place by New York legislature that offered relief for religious educational funds. And so the ruling went that generally available aid can be given to religious educational institutions as long as the fundings are not used for religious activities or upkeep. The court noted in the case that since the grants provided by the tax relief could not guarantee the separation between secular and religious educational functions, the relief program had to be shut down. And we can see that the fact pattern is the same.
But Counselor, isn't a more relevant case Zellman versus Simmons-Harris? How come the vouchers in Zellman are permissible, but the vouchers in this case are not?
I believe my partner can answer this question more succinctly than I can.
Please.
Sorry, you just cut out there, Your Honor.
The question was about Zellman versus Simmons-Harris. How is your case different from Zellman?
Right. So I think in Zellman-Harris, the big difference is that the primary effect does not advance or inhibit religion. And in Montana, I think the primary effect does advance religion of the scholarship, of the indirect scholarships and government aid.
How?
Because in Zellman-Harris...
Well, how does Montana want to advance religion?
Because I think, Your Honor, you see that these scholarships have been creating opportunities for students who aren't able to go to these religious schools without them. And then you see that is directly furthering the religious education of these students. Yet in Zellman-Harris, the voucher program was available for public and private schools, not just private schools, not just religious schools. Zellman-Harris was this true Your Honor, it was this true program of private choice. And so we see there that Zellman Harris, the 5-pronged tent that they've mentioned, this was entirely neutral to religion. The Zellman Harris program was entirely neutral to religion in a way that Montana is not. And again, the question here is not whether that sort of program is allowed, but whether or not invalidating that program is allowed. And Locke v. Davie shows us that they're allowed to level down in this way and that the invalidation is permitted. And in fact, in the dissenting opinion in Locke v. Davie, Justice Gorsuch mentioned that one of the potential ways to deal with the issues created...
Wait, you say Justice Gorsuch?
I think that was...
Are you talking about Trinity Lutheran or Locke? No, it wouldn't. Gorsuch was on the bench yet. Locke v. Davie was 2004.
Yeah.
Your Honor, this is Justice Scalia.
Okay, Scalia.
Yeah, sorry.
I like both of them very much. Okay, well, he filled the Scalia seat. Okay, go ahead. Proceed. Counsel, your cup. Lance, you want to...
Of course.
Sorry, so, you cut out. Oh, Lance, sorry, you're talking. Sorry.
Of course. So back to Nyquist. So since they're due to back to the potential. So the court noted that since the grants could not guarantee the separation between church, secular, and religious education functions, the relief system had to be shut down. In addition, the court also noted that due to the potential for government entanglement, the tax relief system could not exist, even though the money was given to the parents instead of directly to the schools. So in this case, we're seeing that an important point to note is that going back to the original, back to the Danbury, back to the original intent of the free exercise clause, the point was not to protect the state from the church. The point was to protect the church from the state. And we can see that from the values present in the Lemon test, we can see that it is a value of the state. It is a value of the state to keep the church separate from its functions, as to not have a corrupting influence on the religion. Because in government consists of multiple compromises and dealings with haves and halves, and religion does not follow the same ideology. Religion is about a truth, a generally accepted truth with no compromise. And so to have a compromising system interact with a non-compromising system that people believe in, then that can lead to a corrupting influence. And so that's the reason why it is incredibly important.
Right, but counselor, in this case, if I can interrupt for a second, in this case, don't we have the people of religion? The school wants this, right? You keep saying religious groups don't want it. Here they want it. Why should we tell these religious groups that they shouldn't be allowed to accept this funding if they think it helps their faith?
Well, Your Honor, this is because the funding comes from. First of all, I'd like to preface this with saying that there was no provision within the tax credit program that said that the scholarship money could not be put towards a religious purpose. And so with money coming from the government into the schools, with the money coming in from the government to the schools, the government now has money and now has leverage over the school.
Lance, I think Elliott is raising. Elliott, do you want to jump in?
Oh, my apologies.
No worries. I just like to address your question a little bit, because I think it's obvious that when you have any group, you're going to have some people of some group who believe your side and some people of some group who believe the other side. And I think the point is that, yes, maybe in this case, these specific religious groups do want this scholarship. But if you look back to the 1972 renewal, you'll see that when they were discussing adding this new no-aid clause back into their constitution, many religious leaders agreed with approving the no-aid clause because they wanted to prevent from that type of undue entanglement. And I think that, yes, just because this group might want the funding, but there's many other religious groups in Montana who also might not want that funding, and that the government does have this vested state interest in ensuring that role of separation that has no religious hostility behind it.
Okay, you proceed. You have about 1 minute and 45 seconds left. You proceed.
Elliott, would you like to continue, or would you like me to continue?
I'll continue now. Thank you, Your Honor. Our last point we'd just like to say is because of all of these reasons, Locke v. Davies shows us that Montana is not required to have this tax program. Zellman v. Harris shows us that even though that Zellman v. Harris is vastly different from this case just because of the differences in between the public and private choice and the effect of advancing or inhibiting religion. And for all these reasons, we urge the court keeps the Montana Supreme Court's ruling and says that no, it does not violate the Free Exercise Clause to invalidate this generally available program because the legislator is not required to give out these aid to students. Lance, if you'd like to finish.
Of course, Your Honor. As a closing remark, consider this. The appellants are pushing because if they get denied government aid, they cannot send their kids to a religious education. This means that the appellants rely on government money to send their kids to a religious education. In this way, government funding would be directly responsible for furthering a religion. We urge the court to uphold the previous court, the lower court ruling, and have the invalidation remain standing. Thank you, Your Honor.
Okay. Thank you so much. Right on time. All right, petitioners, you have 5 minutes rebuttal. You can begin whenever you're ready.
Yes, Your Honor. The separation of church and state isn't constitutionally mandated as nowhere in the Constitution is state. However, what it does state is that government should not use their power to treat religiously and non-religiously affiliated people differently. The state should not and cannot use the principle of a separation of between church and state as a basis for discrimination, which is clearly what is happening in today's case. Montana's reflection of this standard is abusing the principle of having a separation between church and state and is discriminating against its own citizens. And while it's in the power of the states to express their right to write their own constitution, it is not within their power to supersede protections given by the supreme law of the land. In this case, the only form of aid is the way that private citizens donate to scholarship organizations, which clearly differs from the case of Committee of Public Education v. Nyquist, as the money in Nyquist went directly from the government to schools for maintenance.
But Counselor, doesn't I'm sorry, let me interrupt. Doesn't the fact that you have these intermediaries make this policy better? In other words, the state isn't choosing where the money is being sent. The state is letting private citizens choose it. So the state doesn't actually involve itself. Doesn't that separation help the other side of the case?
Well, no, Your Honor. The separation between where the money is going, it's not going from the government to any kind of religious institution, which is what the opposing side is trying to argue. It goes from private citizens to scholarship organizations. So it is not within the government's right to try to invalidate such a tax credit program just because they do not want to benefit any religious institution.
All right, you can proceed, Counselor.
In the case of Nyquist, money went direct from government to schools for maintenance, but in this case, this money is tuition that schools are free to use for what they'd like. However, since this is a school, they can't be invalidated from the program just because the state simply doesn't know what the money could be used for. The state never made an attempt to make regulations about what the money from the scholarship program could be used for, so leveling down for this reason doesn't make sense. The respondents misused Nyquist to show where the money could go, but in Nyquist, money solely went to maintenance, whereas in this case, there is a valid non-secular purpose, education. This just goes to show the unconscionality in this case.
But how do you respond, Counselor, to the arguments about church lukumi and religious animus?
Can you repeat that, Your Honor?
How do you respond to the case of Church the Lukumi? Oh, I think she froze. Yashica, can you maybe try that on Church the Lukumi? Are you familiar with that case?
I'm not familiar with this case.
Okay, Elizabeth, sorry, I think you're back. Are you familiar with the Church the Lukumi case?
The Lukumi Babalu?
Yeah, that's it.
Well, Your Honor, I feel as though that is talking about whether or not the state can intervene when there's something that goes against another law or regulation, but in this case, it's simply about religion. There is no inherently criminal thing happening in the case case as there was in the King so I don't feel that this goes to the case of Espinoza Department of Revenue.
All right, Council, you have about a minute and a half left. You can proceed.
Well, if this were a military school wanting to use government aid to buy rifles for the drill team, this would be found constitutional. But in this case, because the distinction is religion, it is unconstitutional, which doesn't make sense. This program can't be simply invalidated because of its religious status. That just shows the simple determination that Montana's Constitution is trying to show. And Locke v. Davies and Chief Justice Rehnquist quoted from Walls v. Tax Commission that the general principle deducible from the First Amendment and all that has been said by this court is that we will not tolerate either governmentally established religion or governmental interference with religion. And the tax credit program in this case did neither. The respondents also misused Locke v. Davies and tried to relate it to this case when they are clearly different. In Locke v. Davies, higher education is being pursued, and this case is 12 education is being pursued. Now, if this were a case of students going to a historically black college university or a primarily white institution, the matters of discrimination would be day and night. But both racial and religious discrimination are analyzed constitutionally under strict scrutiny and should be treated as such. The law in this case did not avoid religious entanglement, but simply furthered it, because the state invalidated a program that they created because they didn't want to benefit religious institutions. It is for the reasons previously stated that we pray that the court notices the blatant unconstitutionality of the issue of Rule 1, reverses the Montana Supreme Court's decision, and rules in favor of the petitioner. Thank you.
Okay, thank you so much. And that brings this round to a close. Thank you to the petitioners. Thank you to the respondents. You did
Respondents still have to rebut.
Oh, I'm sorry.
We've had a long day.
I've been doing this for 4 hours. I'm so sorry, Elliott and Lance. I apologize. You have 5 more minutes. I'm sorry. You did a great job so far, but you can begin 5 minutes.
No.
Because usually in court, only petitioners get rebuttal on the click my mic. Okay, go on. 5 minutes. You can be whenever you're ready. I'm so sorry.
Thank you, Your Honor. First off, I'd just like to discuss what we've been discussing about the constitutionality of no-aid amendments. The petitioners have been discussing that the no-aid amendment is unconstitutional as applied, but everything they've said has led me to believe that they are actually arguing that the no-aid amendment is unconstitutional on its face. And I'd just like to talk about why the no-aid amendment is not unconstitutional. If you look back at the history, no-aid amendments have been present since the founding era. In fact, 13 states had no-aid. 9 states had no-aid provisions, while 13 also had a free exercise clause, and it's clear that the original intent was that no-aid clauses and free exercise clauses could exist simultaneously, and that the no-aid amendments were not originally violations of the Constitution. I just also like to argue about the fact that they're saying that absent Rule 1 is unconstitutional. The Montana State Constitution says that the legislature, counties, cities, towns cannot grant any aid to church, school, either indirect or direct appropriation. And it's clear in this case the tax credit program is an indirect appropriation of funds. The $1 tax credit program is a clear indirect appropriation of funds, and for this tax
But Counselor, let me interrupt you just for a minute. The state is not choosing where the money goes. The state simply says, whoever private citizen sent it, that's it. The state has no involvement. Doesn't that separation take you out of Locke in these other cases?
No, Your Honor, because the separation is the tax credit program in this case is it's a one-to-one tax credit. So they give $150, they get $150 back. In that way, it's essentially like the government is just giving the money to these scholarship organizations, to these schools, directly funding this religious organization. And it isn't the same sort of, it really is directly going to these religious schools, and that's why Locke v. Davie does apply in this case, because it's the same sort of scholarship, has the same sort of effect on religion.
Okay, you can proceed, Counselor.
I'd also just like to address some of the points that the petitioners have been making about how if this was race or if this was in the military, this would be an entirely discriminatory. I know we aren't getting into equal protection if it was in the limits of this competition, but I just do want to say that there is historical precedent for the reasons why religion is treated differently than the other issues such as race, such as if this was in the military. And I'd just like to point out that just because those things might be unconstitutional when it comes to race, if it comes to their other examples, there is no religious hostility and there is no religious discrimination in this act, in the Montana Supreme Court's invalidation of the program. Lance, if you'd like to go from here.
Okay, about 2 minutes left.
Got it?
Yes.
Okay. Our opponents have also been saying that this has been equally affecting both religious and non-religious students. However, in the facts of the case, it's stated that 94% of the scholarships that we are discussing actually went towards religious schools. So here we can see actually a disproportionate impact affecting positively towards religious schools. Another point made was that this is a discrimination against religion. However, there's actually, as stated in Locke v. Davie, the Establishment Clause sets a baseline for what the government can't do, and the Free Exercise Clause mandates what the government must do in order to protect religion. But in between those, there's room to play within the joints, and so states have you could say their own agency in choosing to what extent do they want to fund religion. And so in this way, the state's actions are permitted. Elliott, do you have anything more to say?
Yeah, you have about a minute left, Counselor.
Yes, Your Honor.
Yes, Your Honor. I'd just like to point out that because of the Montana State No Aid program, this tax program cannot exist without Rule 1. And even the Montana Supreme Court, even if we concede that yes, maybe Rule 1 is discriminatory, the only option for the Montana Supreme Court was to invalidate the entire program for both secular
I get that,
and
but then we can just respond by declaring the Blaine Amendment, the No Aid provision, unconstitutional, right? Isn't that?
Right, but then
Go ahead.
Right, I don't think that the no aid amendments are unconstitutional because you also have to look at the impact. If we're going to declare all 37 no aid amendments unconstitutional, that does have a big impact on the state, and the court generally does not like to make these sort of radical changes. Generally takes to be more incremental in your rulings. And I think
Counsel, that's time. You can finish your sentence.
Please side with the respondents and say that it is not unconstitutional to invalidate the tax program.
Okay, thank you so much, Elliott and Lloyd. Elliott and Lance. Elliott, Lloyd, yeah. Thank you so much. Now I can give you your praise that you so richly deserve. That was fantastic. My questions are hard deliberately. I am trying to push you. And I'll even ask you things that I don't think you know the answer to because I want to see how you respond. And it will happen one day that you're in court or maybe in a law school class and someone asks you a question you have no idea. And you can say, Your Honor, I don't know. There's nothing wrong with saying that. It's worse to pretend you know because you get slammed in 2 seconds, right? You say, Your Honor, I'm not sure. And at that point, the judge will tell you, well, here's what I'm thinking. And then you have to think on your feet and say, oh, that's what you're talking about. Then give an answer. And I think you all did that quite well. I asked you about Trinity Lutheran. I asked you about Article 3 standing. I asked you about the Gorsuch concurrence. I think you did very well. You're well prepared. I'm very, very proud of all of you. I truly mean it. I mean that sincerely. I could not have done this when I was in high school, without doubt. Not even close. I would have been creamed. Would have made it past the first round. Sebastian, is there anything you'd like to add for us?
Yeah, I'll second that about not having been able to do this in high school. You all are obviously put through the ringer with a lot of these questions that Josh schemes up. But you all handled them with aplomb, so you should all be very proud.
Very good. Do you have any questions for me or Sebastian? We'd be happy to answer them about anything, really.
I actually have a question.
Yes, please.
What do you recommend for us carrying forward as we learn about the Constitution and about law? What do you recommend?
Oh, what a good question. Well, what year are you? All of you. What year are you all in school? Freshman, sophomore, junior, senior?
Sophomore.
I am a freshman.
Freshmen. Okay.
I'm a senior.
Okay. Well, the seniors, you guys are off to college soon, so you'll be taking classes. But I encourage you to debate team, mock trial, right? The We the People competition is very good. Play an art competition again next year. It's fun. But also read a Supreme Court decision, right? Every year they release big ones. Try to read one straight through that really appeals to you. In fact, with Espinoza, right? When this case comes out, try to read the entire thing. See how you guys fare. It's going to be 100 pages long, but see if you can read it. But I think you guys are capable. I have full faith and credit that you'll be able to do it. What other questions you guys have? Thank you. No other questions? Well, I know at least 2 of you are in Texas. If you're ever in Houston, you're welcome to come visit my class. The door is always open. You're welcome to come by. I mean that truly. Just email me. Oregon's a little bit further away. I'm sorry. But you're welcome to come anyway if you're in Houston. But yeah, you have to run. The airport's not very open right now. That's all I have. You guys did great. We'll put these on YouTube a little bit later today. And hopefully we'll email your teachers tomorrow. And but in any event, very proud of you all and wish you the best of luck. So thank you all. Have a great day. Bye.
Thanks.